Hi, everyone. This is Sam Silverman, Managing Partner, EB5 Affiliate Network, joined by my partner, Mike Schoenfeld, and Ron Klasko and Dan Lundy of Klasko Law. Thank you for taking some time to join us today. We're going to cover the recent EB5 redeployment policy change announcement that was made by USCIS in the last week. And we're going to address some of the key questions that are now coming up for both project sponsors and EB5 regional centers. As we go through the presentations, please write any questions that you have. Use the chat box that's on your screen. And at the end of the presentation, we'll leave some time to go through those and try and address as many of them as we can. So first is a quick overview of table of contents of what we're going to cover today. First, a little bit about Klasko and EB5 Affiliate Network, high-level summary of the redeployment process, what the changes that were announced by USCIS are, some of the key questions and impacts facing regional centers and project sponsors, then how to select a regional center to rent or expand a regional center that's already existing going forward, taking into account the rule changes that were announced. And then we'll wrap up with a short question and answer session at the end. So first, as I mentioned earlier, I'm Sam Silverman, Managing Partner, EB5 Affiliate Network, joined by my partner, Mike Schoenfeld. We're a national EB5 consulting firm. We work with a lot of regional centers and project sponsors to help provide access to regional centers across our network. I'll let my partner, Mike Schoenfeld, jump in and introduce himself.
Hi, everyone. Hope you're all doing well. As Sam mentioned, we're excited to be on the webinar now speaking about the redeployment changes from USCIS. We're one of the largest regional center operators in the country with 14 approved regional centers covering over 20 states. We've sponsored over 100 projects and are known as one of the best-in-class operators in the space. And with these surprising changes from USCIS, we wanted to invite Dan and Ron on the phone to help explain what this means for projects and investors. And we look forward to any questions you have. Please put them in the chat box and we'll address them at the end.
Great. Thank you, Mike. We'll turn it over to Ron and Dan and go from there.
Sure. Are we talking about background or are we just going into the stuff? So
just background for now.
Okay. Ron Klasko probably needs no introduction. He is the managing partner of our firm, Klasko Immigration Law Partners. He's been around EB5 and immigration for a long time. Is generally regarded as an expert in the field. Myself, I joined the firm about 8 years ago, and I've been practicing primarily in EB5 for that time. I've represented quite a large number of regional centers and projects and investors, and particularly troubled projects. So our firm is pretty much at the cutting edge of EB5 and immigration in general. Next slide. Okay, so redeployment came around because USCIS has this requirement that the investment must be maintained at risk throughout the conditional residence period. Around 2012, we realized that with USCIS processing delays and visa quotas and backlogs, that the traditional 5-year period that of the EB5 investment, either 5-year loan or 5-year investment that everybody had contemplated, was probably going to be too short, and we were going to need to do something with the money to keep the money invested at risk. So as a result, redeployment came around. The idea was, if you have put the money into the original project, followed the business plan, all the jobs have been created, and the money comes back to the new commercial enterprise, then you could redeploy the money into a new investment in order to keep it at risk. Unfortunately, until just a few days ago, USCIS had given us very little guidance on what qualified as a redeployment. They didn't tell us whether or not it had to be in the same regional center, a TEA. They didn't give us almost any guidance at all as to what kind of enterprises or activities would qualify as a redeployment. Next slide. as I was saying, the original timing, we figured, you file a 526 petition, and depending on how lucky you are, a USCIS is taking somewhere around 2 to 3 years to process. After USCIS processes the 526, you have to file either a DS-260 application for immigrant visa or adjustment of status, which takes, on average another year. Of course, you can't apply for that until your priority date is current. So after you've now waited another year or so to get your adjustment of status or your visa application approved, and you've entered the country with a conditional green card, or you become a conditional resident, that starts the 2-year conditional residence period. Now, between 21 and 24 months after that, you have to file your 829. But after 24 months, at the end of the 2-year conditional residence period, you're actually allowed to get your money back even if your 829 is not approved. You, however, must maintain your investment at risk throughout the entire 2-year period. So that means that we have to redeploy. But one of the problems that we had and USCIS hadn't answered is, well, it takes time to redeploy. If you're a regional center or a manager of a new commercial enterprise, you have to find a new investment. You have to do due diligence. You have a duty to the investors not to just throw it into anything, right? You have to find a project that's not going to lose, hopefully not going to lose the money of the investors. So we didn't know, USCIS had said that you had to redeploy within a reasonable time, but they didn't define what a reasonable time was. So the new policy has clarified a couple of things. It said, one, a reasonable time is generally 12 months. If it's longer, through extraordinary circumstances, they may consider it, but 12 months is a de facto reasonable period. Number two, they've clarified what you can redeploy into. First, they said that you have to redeploy into the regional center, which is, into the geographic territory of the regional center, which is totally new to us. They previously had not said that, and in fact had indicated that and then backtracked on it during some stakeholder calls. So this is a totally new requirement that caught us, somewhat by surprise. They did say, one of the nice things that they said, there are a few good parts to this policy. One of them is that the investment, if it was originally in a TEA, it doesn't have to be redeployed into a TEA, because presumably your investment in the TEA created the jobs and improved unemployment in the TEA. Now you don't have to invest in the TEA. What they did say, though, as opposed to in terms of what you can invest the money into, basically any activity that is in commerce, which they define as the exchange of goods and services. They specifically exclude purely financial activities such as the purchase of securities on the secondary market. You can't put the money in an investment account, at a brokerage firm and trade stock with it, even though by all means that's at risk, right? And there's no question that that's at risk, but they're saying that is not sufficiently in commerce. This is not to say that you cannot redeploy into a bond offering where you are purchasing the initial offering of the bonds, and the bonds are used for construction. So they had previously allowed for municipal bonds that were intended to finance construction. It seems to us that is still allowable, provided that you are actually buying the bonds on the principal offering and not trading them on the secondary market. Another thing that they said, which we had pretty much assumed, but they clarified, is that you have to deploy through the same new commercial enterprise. You can't redeploy the money into a different new commercial enterprise. This has some implications that we'll talk about later, for troubled investors. But in general, for most projects, that's not really an issue. Ron, did you have any other pearls of wisdom you want to throw at us from the guidance?
What I would say is that by and large, this policy is very consistent with what we expected would come down. The industry has been pushing real hard for guidance because there have been many open questions. I think in discussions with our regional center clients, there really are two major issues of concern coming out of this. Number one is the requirement that the regional center, that the redeployment be in the geographical boundaries of the regional center. And there are many regional centers who have already redeployed capital and redeployed outside of the boundaries of the regional center, because that was completely consistent with any previous guidance that was given. Well, that's bad, but what makes it even worse is that USCIS has stated unequivocally that they plan on requiring that redeployment in the regional center boundaries retroactively, which means that redeployment that's already occurred outside of the regional center could result in either 526 denials or 829 denials, which will almost certainly be challenged in court. And again, from our discussions with our regional center clients, we're quite confident this is likely to happen. And especially because of the retroactivity issue, I think the chances are good of one of two things happening. Either the Immigration Service will back down from the requirement of applying it retroactively, or if not, that the federal courts will shoot it down, at least with respect to the retroactivity provision. There's a very good argument that once the jobs have been created and the business plan has been implemented, the regional center geography should no longer be relevant. In addition, the regulation only talks about sustainment at risk. So everything else is outside of the requirements of the regulation. And the only thing that is considered the law, as opposed to whatever the latest policy of the Immigration Service is the regulatory requirement that it be sustained at risk, and certainly redeployment in an active enterprise outside of the regional center meets the regulatory requirement of sustainment at risk. The last thing I'll mention is certainly going forward, to the extent of future redeployment, and to the extent that you want to do everything you can to comply with the latest USCIS policy, certainly we would advocate that our clients redeploy within the regional center boundaries. And what that means, and I think Sam and Mike are going to be talking about this, is that a regional center with wide boundaries becomes maybe more important than it's ever been, because it now provides more geographical space to perform the redeployment. And again, as I think that Mike and Sam will talk about, there is a procedure for regional centers to expand their geographical boundaries, and there may be more of that going on in light of this new policy on redeployment.
So Ron, one question that I had is, this seems like it caught everybody a little bit off guard, where there were some things in the redeployment guidance that make sense, and there's other things that don't make sense in terms of being retroactive, and some would argue being within the same geography of the regional center. What is your thinking on if clients are going to challenge this now, or wait until there's I-526 and 829 denials before anybody tries to talk to USCIS and get these policies changed?
Yeah, so as you know, our firm does a lot of EB-5 litigation, and generally our advice would be not to litigate based on simply the issuance of this policy. We've already seen that they've changed policy once. They may change policy again. I think you have to wait until somebody is actually harmed by this. It is conceivable that a regional center could say, could try to go into court now and say, we've already redeployed outside of the regional center. Our investors are already concerned, and we want the court to clarify this. I think most likely this is going to come up either if a 526 is denied on this basis, or if an 829 is denied on this basis. With a 526, at the time of filing the 526, redeployment is not an issue. So it would have to, in the 526 context, there would have to be an RFE that is issued years after the 526 is filed, saying, please advise us if the money is still in the NCE, if it's been redeployed, and then we'd respond to the RFE. And if that resulted in a denial, we would be in a position to litigate that denial. On the 829, it is, on each case, it's going to be a little bit different, but it may well be that the documentation that's required to be submitted with the 829 is going to reveal that some or all of the redeployment was outside of the regional center geography. And we will have to see if the Immigration Service is prepared to actually deny investors and put them into removal proceedings for actions taken by the regional center that were perfectly legal and in conformity with the USCIS policy at the time those actions were taken. I'm not so sure that the Immigration Service is going to do that. So, although I could see a possibility of litigating right now based on the policy, I think it's more likely that the litigation will await an actual denial by immigration of a 526 or an 829. Dan, do you agree with that?
I agree that litigation now would be more difficult because there's a complicated standing issue. But on the other hand, I think, well, one, there's a comment period through August 24th, and I think everybody in the industry has to comment on how that retroactive application of this would be unfair and terrible. But failing that, if they don't backtrack after that, I think I would be willing to go for it. Yes, you have a much stronger case when somebody's actually denied, and you might get thrown out on the basis that nobody is, going to be imminently harmed. But there needs to be some certainty in EB-5, and I think it certainly would be justifiable to file a lawsuit now. So
thank you guys.
Go
ahead, Jen.
So it's not actually in the policy manual. USCIS issued a Q&A that's actually pretty hard to find, but it's on their website. And it says that the investor, if there is a redeployment of the money and the 526 is pending, the investor has an affirmative duty to make an inner filing to let USCIS know, which would then trigger your RFE.
Got it. Thank you, Dan. One other question that kind of comes up in this same vein associated with the redeployment question is, a lot of projects, when the initial construction is completed, the money oftentimes isn't necessarily repaid to the NCE and then reinvested into a new project. Oftentimes, as you've seen, largely in condominium projects, for example, the funds are sold, the project is, completed, but then the collateral of that investment changes. So the money is not repaid and then reinvested, but the collateral for the original loan just becomes something other than the original building because that building has now been sold. So in your opinion, is that still redeployment, and does that still fall under the same rules of having to be reinvested within 12 months and in the same area? Or is that really not redeployment in that the money is still outstanding other than the original loan, but just the collateral has changed?
Well, every case is going to be different on the facts, but from what you described, so if the borrower still has the money, then the money is still at risk, right? It's only when the money comes back to the NCE that you're going to have to redeploy it, or if there's some arrangement, like you couldn't have an arrangement where the borrower or the JCE says, okay, we're going to put the money in escrow and just let it sit there until you can get repaid. But if the borrower has possession and control over the money's at risk, and it doesn't need to be redeployed.
Got it. Yeah, that makes sense. Okay, we'll move on to the next slide here. So walking through some of the questions and impact of the policy changes that Ron mentioned earlier. So, what are some of these key questions? Dan covered this one largely. So, what happens if a project already redeployed funds? We talked a little bit about that. Second, how can geographic coverage area of a regional center be expanded? The process for that is through a Form I-924 amendment. Initially, when a regional center is set up, it's the same Form I-924 for initial designation as it is for the amendment for expansion. So you would file the same form explaining that the regional center has already been established and provide additional documents either for hypothetical projects, which would be most likely, or a specific exemplar project that you're looking to get approved. And through that amendment, you would be asking the USCIS for an expansion of coverage area. So if your regional center initially was designated for 10 counties, 10 contiguous counties, but you wanted to expand to cover the remaining 20 counties in that state, let's say, for example, then you would need to provide either hypothetical projects or hypothetical and exemplar, or just exemplar project to justify an economic impact of those new projects across the additional 20 counties that you'd be seeking coverage for. So it's a very similar process to the initial designation, but now you're going to be focused much more on providing details on the impact of the new projects in the new area, and you're not going to be providing a lot of the information about the governance and about the marketing strategy and the operational plan. All of those items will have been already addressed initially in the first I-924 filing, and they won't need to be resubmitted in the amendment filing. So second, this is an important question. So can a project change regional centers to expand the area in which EB5 funds can be redeployed? So of course, if someone has a project that only covers 3 counties, and then now they want to redeploy in the whole state in a much larger area, can they change regional centers? Now, there have been some situations where USCIS has approved change of regional center, but normally that occurs when there's an issue of fraud or the previous regional center has been terminated. But I'll let Dan and Ron kind of jump in to address this more immigration style question.
So the position of the Immigration Service, which we do not agree with, but the position of the Immigration Service is that any change in regional center, whether it's voluntary or because of the termination of the original regional center, constitutes a material change. And if that occurs before the investors have conditional residence status, it would result in the denial of the investors, and they'd have to start all over again. That position of the Immigration Service is being challenged, I know, by our firm, and we are actually preparing to initiate an action in federal court on that issue. For now, we just have to say the position of the Immigration Service is that a project cannot change regional centers to expand the redeployment area, at least before all of the investors have conditional residence status.
And so, Ron, to follow up on that, how does that interpretation or application possibly change if the investors have already gotten their conditional residence status and you're within that 2-year conditional residence period during which the redeployment would be most likely to occur anyway? So if you had a project with 10 investors, they all get their 526 approved, but they're in a regional center that only has a few counties, and now they have a new project they want to put the money in, but they need to change regional centers, or they want to change regional centers to get the bigger coverage area. Is that automatically going to trip the material change and create a for sure problem for those investors, or is it more likely that that type of a change in regional center following the 526 approval and conditional residence period start, could that be could you take that? Would you be comfortable taking that position, or how do you think the USCIS would approach that?
Yeah, so this gets a little confusing, and let's just make sure we do it step by step. So the issue of when you become a conditional resident is the trigger point for material changes. So a change of regional center is a material change, but that's cut off once you get conditional residence, because the material change does not affect an investor after he gets conditional residence. Now, the next issue then is, well, what is the period during which the investment must be sustained at risk? And the Immigration Service says that that period is 2 years after conditional residence. So to the extent that the redeployment policy relates to this sustainment at risk period, then I certainly think the most conservative way of dealing with things would be to say, well, during that 2-year period, you're subject to the Immigration Services rule or policy that any redeployment must be within the boundaries of the regional center, and it appears that they're defining that as the regional center at the time you filed. What I think we don't know 100%, and remember, we're not talking about the law here, we're talking about their policy, which is changing. I don't think we know exactly what their policy is on where everything, we meet the all of the redeployment requirements, except for the fact that we have now changed regional centers after the investors got their 829, got their conditional residence. And we're going to continue to meet the redeployment requirements by changing regional centers to make sure that the NCE is now within a regional center where the redeployment will be included in the regional center geography. I fear that the Immigration Service position would be that you can't do that, but I do not know that that's 100% certain as to what their policy is right now.
Got it.
Okay, great.
One final question we had on this slide is the effective date. So we talked a little bit about retroactivity at least in the official policy alert memo that I saw. There were placeholders for the dates. How do we know for sure that that's going to be retroactive, or that that's still being discussed and is part of the reason why they're holding this Q&A, and they may in fact just take the position of putting that date sometime in the future with a little bit of advance notice? Why do we think it's definitely going to be retroactive?
Well, the easiest answer to that is because USCIS issued questions and answers, and they stated very specifically that because they view that this guidance simply updates or clarifies their existing policy, that they will apply the July 24, 2020 policy memo to all 526s and all 829s that are pending at the time as of July 24th. So they have specifically said that they will apply this retroactively.
Got it.
Okay, and I think
right.
that leads us well into the next slide, which really this is a question that I think everybody on the webinar probably has, is so now that this has been released, what can we do, both for current projects and then in the future, making sure that we follow the rules right? What is your current thinking on what to do to make sure that you're covered and won't run into any problems?
Is that for us, guys, or are you taking that?
Yeah, I can start.
That's for you.
The most conservative thing to do is to redeploy within the regional center territory.
And if you're planning on redeploying outside the regional center territory, then to try to, depending on where the redeployment is, try to get the regional center to expand through an I-924 filing, expand its geographical territory before the redeployment takes place.
Okay, got it. And I would also say that if anybody is in the situation now where you have already redeployed in things that don't qualify under this, it might be a good time to reach out to Dan and Ron to start talking through what your options are on that and what the best path forward is.
Yeah, exactly. And again, we would, whether it's a regional center contacting us or an investor contacting us, we would have the discussion in some more detail about whether it makes sense to wait to see what immigration does and if they in fact deny your application, or whether it's worth the, as Dan mentioned, the higher risk litigation or more difficult litigation of trying to get this policy enjoined or stopped before anybody's actually even denied.
Exactly. So,
and then go ahead, Sam.
I guess to summarize, for future EB-5 projects, for projects that have yet to be sponsored and start taking in EB-5 investment, now, given these policy changes, selecting a regional center is now more important than ever. And as Ron mentioned earlier, it's now much more important to consider the entire approved geographic scope of a regional center, because that's really the area where you're going to want to redeploy the funds if your project is going to face a redeployment issue down the road. So in addition to the most common diligence items that you want to look for, track record, number of investors, etc., you also now really want to look at regional center approved geographic coverage area. And for current projects that are now sponsored, that are projects where the developer or the sponsor knows that that project is going to be sold, or there's going to be a capital event at some point, likely during or before the investor's eligible for repayment, those are the projects where, looking a few years out, where you probably want to say, hey, we probably don't have a project, or we don't want to try to find a project within the currently approved geographic area. And we're going to want to file an expansion now, so that by the time redeployment does come up, years down the road, we'll have much more flexibility with a greater geographic coverage area in which we can redeploy the funds. All right, so now we'll spend just a few minutes on selecting a regional center or expanding. So as quick background, as Mike mentioned earlier, EB-5 affiliate network, we own 14 regional centers that currently cover more than 20 states, including Washington, D.C. Some of the approval letters are there on the right side. We're one of the few regional center operators that has figured out how to get large geographic coverage areas approved. So all of our licenses cover entire states or multiple states. And as an example of regional center expansion, we've done a number of expansions all around the country. Under the current policy, if a center was approved just for a few counties, let's say in South Florida, but then additional counties were targeted for redeployment. So let's say your first project was condos or a hotel in Miami, and it went well, but then you sold out all the condos, or you decided to sell the hotel once it was stabilized, and then you wanted to redeploy the funds, but you wanted to redeploy them in a deal in Orlando, then you would need to have an expanded coverage area that covers all the way up through Orlando in order to be able to do that. So that's just kind of a visual example of what the implications of an expansion look like and how that could actually happen in a project. And again, you would only be looking to do this if you knew that your project was likely going to have a redeployment at some point in the future, and it was going to likely be in an area that you weren't currently approved for under your sponsored regional center that you started with. And these are a couple of regional centers that we had, one that covered the Southeast, one that covered the West Coast. Both of those have already been sold. We do still have one available that covers several states contiguously in the Northeast as well. All right, now we'll open it up for questions. I know we did get a few questions during the webinar, so bear with me here and let me pull those up, and then we'll try and cover a few of them here at the end. Let's see. Okay. Okay, let's see. Okay, one of the questions that we received is, is the new change applicable to new applicants only, or does it impact old applicants as well? I think Ron addressed that earlier when he said that the currently published version is retroactive. Is interfiling required for all redeployment, or only if the redeployment would be considered a material change? I'll let Ron or Dan jump in on that one.
Well, according to the Q&A, it seems like all redeployment.
Got it. Okay. What if the developer is no longer interested in continuing with the project and decides to stop construction? What happens to clients who are in between I-526 and IA-29 processing period?
So this is going to be very complicated and fact specific, but the key factor is whether or not you've gotten your conditional residence. If you're a conditional resident, then the material change issue doesn't necessarily apply to you. If you're not a conditional resident, material change still applies, and if you basically, if you want to redeploy your money into a different project than originally contemplated, USCIS is going to call that a material change, and your 526 will be subject to denial or revocation. Afterwards, if you can keep the NCE and the NCE can redeploy, or deploy into a different project, you may still be able to keep your green card, but only if you've already gotten that conditional residence.
Got it. Do these policies impact redeployment that's occurring during the pending IA-29 petition stage, or is this really only applicable during the time leading up to IA-29 submission?
Well, so technically after the end of the 2-year conditional residence period, you can get your money back. So, some of the agreements still require you to keep your money invested, some don't, but if you do, and they're, it's redeployed after the conditional residence period, then USCIS shouldn't have anything to say about it, because technically you could have gotten your money back and it's no longer an issue.
Yeah, I agree, Dan, completely. As I see it, what they're doing with this policy is defining what is considered to be sustainment at risk. And that's what all this is about. And since the sustainment at risk requirement only applies to the 2 years following conditional residence, I would certainly argue, and I think the Immigration Service would agree, that all of this is irrelevant to redeployment that occurs after the 2-year sustainment at risk period.
Got it. One other question that we did get is, what do you make of the fact that the policy manual, the updated version, deleted the sentence? Similarly, the new commercial enterprise may also further deploy repaid capital into municipal bonds, such as infrastructure spending, etc.
Well, again, they have eliminated trading securities or financial instruments on the secondary market. However, you may be able to still buy bonds on an initial offering, that fund construction that may still qualify, but it's going to be a case-by-case, analysis.
Yeah, I can't imagine that they're going to somehow say that those redeployments were somehow not in conformity with their policy. Now, it's one thing when we're talking about the original policy didn't specifically say that the redeployment has to be in the regional center boundaries, and now they're saying it is. There is that requirement, and I think that's outrageous that they're trying to do that retroactively. It would be at a whole other level of outrageousness if they said specifically that redeployment into those municipal bonds was perfectly acceptable in their original policy, and now they take the position it isn't and take that position retroactively. I can't believe they're planning on doing that.
If investors in a project had already redeployed out of the initially approved RC geography, could they go back now to the RC and continue to redeploy those funds under the RC's approved geography in an attempt to try to address the current policy?
I think that is certainly a strategy that will be looked at by all regional centers that have deployed outside of the regional center geography, whether it's feasible at this point. And there are issues that go beyond immigration law as to whether it is feasible, but whether it's feasible at this point to change the redeployment to something within the geographical area and whether that would solve the problem. I think that's something that's going to have to be looked at each regional center who has redeployed outside of the regional center geography.
And Dan, another follow-up on the bond question, assuming that it was case by case and it did meet the requirement of purchasing bonds in a primary offering, how does the location of the project associated with that primary bond offering have to do with the redeployment requirement? In other words, if you're buying bonds in a project that's out of the RC's approved area or within, does that matter or not?
Yeah, I have to believe that under their policy, which explicitly states the redeployment has to be within the regional center, that it has to be within the regional center.
Got it. Okay. So in other words, bonds may be allowed in a primary offering, but better make sure the project where the bonds are being sold for to fund is in the RC's approved area.
Yeah.
Got it. Okay. All right. We'll do one. We've got a ton of questions here. We'll address one more. I'm just trying to pick a different one. One question we can quickly address is, will these slides be shared? A recording of this webinar will be posted. And if people are interested in getting the specific slides themselves, on the next slide here on the right, if you email info@eb5an in the top right, then we can share a copy of the slides, but a recording of this will also be available to everyone who registered. You'll get a follow-up email with a link as well. Okay, then so last question will be, is USCIS's action legal, given that they provided no notice of this rule, and what coordinated actions can be taken from industry stakeholders, not necessarily investors, to try and push back on this? Is, other than or including the question and answer period, can a formal letter be sent? What other actions can be taken before a rule that is unappealing becomes permanent?
So, whether it's legal or not, we would say that this is in fact a legislative rule, not just a procedural rule. This is a substantive rule change that should have been made with notice and comment. USCIS no doubt would argue otherwise, and that's why they, in fact, state in their Q&A that it's a clarification and not a change. We can disagree on that, but one way or another, yes, it's absolutely essential that as many people as possible comment on this rule by August 24th and tell them that, hey guys, you cannot do this retroactively. It's going to cause all kinds of problems. Barring that, there is always the possibility of litigation. But I really, Ron, I don't see any other options. Do you?
No. So, I agree with you, Dan. Every stakeholder should be commenting and making a special reference to the retroactivity issue and possibly how it would impact the regional center or the project or the investors. Industry groups, IUSA, AILA, others, may be submitting comments as an industry, but the recent history is that the Immigration Service is not particularly interested in hearing those comments, and that leaves planning in each individual case, and it leaves litigation. I really do agree that that at a lot of levels, if this is ever litigated, the chances of the litigation would be successful. When you're in federal court, the federal courts are governed by regulations. They're not governed by whatever the policy is at any given moment of the government agency. In this case, the policy has shifted. If the regulation simply says sustainment at risk, and if you have a redeployment that is clearly at risk, and where the investor's investment has clearly been sustained, the federal court is very likely to not go beyond that. And the fact that the Immigration Service on a Tuesday says it has to be within a regional center and a Wednesday says it doesn't is not likely to be very relevant to a federal court. So both because of what Dan said, that this would normally require what's called notice and comment rulemaking, and they skipped that, and because the federal court would likely look at the language of the regulation, I think if it ever has to be litigated, the chances of success would be good. So when we advise on this, we never look for litigation. We always advise at the first level on how to comply with whatever the latest Immigration Service policy is. And that would apply here also. How can we comply? In the end, if it looks like we can't comply or the Immigration Service is going to take action against our clients, then we would be prepared to litigate it.
And I would like to add that, so yes, AILA and IAUSA are no doubt going to comment, but I think comments from industry groups and interest groups, are not taken as seriously as if a bunch of other, individuals and businesses affected by the rule comment individually. So just because somebody, just because AILA and IAUSA are doing it doesn't mean that everybody listening shouldn't also do it.
Got it. Thank you. With that, I think we can wrap things up, but really appreciate the time of everybody tuning in, and thank you, Ron and Dan, for joining on this and helping provide a lot of guidance with these surprise rule changes that came out. And if anyone has any more questions, you can find the contact information of EB5AN and of Clasco on the screen, and please feel free to reach out.
Yep, thank you everyone. And again, if you registered and tuned in, you should get a follow-up email with a link to watch a recording. And if you did want the physical, just the slides themselves, you can send us an email and we can get you that file separately. So thank you again, and thank you, Dan and Ron, for your time today.